it's Robert Bateman here, and I'm back after a short break with another edition of the Privacy Corner with Privado AI. So this week I'll be looking at the ICO's recently announced investigations into 3 tech companies around their handling of children's data. The CJEU has ruled on what meaningful information you have to give to data subjects if you're making automated decisions under the GDPR. And California has announced an enforcement sweep regarding location data. So we'll take a look at what that means for CCPA covered businesses. So first up, as noted, the ICO in the UK has announced investigations into 3 tech companies over their handling of children's data. So in a press release issued last week, the ICO said it's investigating TikTok for concerns relating to content recommendations among 13 to 17-year-olds, and Reddit and the image and video hosting website Imgur about the company's age assurance measures, so how they verify the ages of their users. And Information Commissioner John Edwards also made a speech at the International Association of Privacy Professionals conference in London yesterday or Tuesday, in which he asked a number of pressing questions. How do these platforms protect children's personal information? How do the recommender systems work? How are they using a 13-year-old's preferences, viewing habits, shares and likes to serve them content and keep them on the platform? And in the case of Reddit and Imgur, how do they assess the age of their users and tailor their content accordingly? Now, Edwards did not reveal whether the ICO was pursuing formal enforcement against the 3 companies, but he did say that other companies, smaller companies including, that are processing children's data, should take the investigative sweep as a sign to get your own house in order. So in 2023, the regulator issued a £12.7 million fine. That's about $16.5 million against TikTok. That investigation, to be fair, was instigated by the previous commissioner, Liz Demon, who initially proposed a much higher fine of £27 million, so about $35 million. And last year, the ICO concluded an investigation into Snapchat's My AI chatbot without taking any formal action, after the company presented the regulator with 5 successive data protection impact assessments and finally got it right on the 5th attempt. The ICO does highlight in the press release some other recent informal action that has led to successes reportedly against 5 companies: X, Twitter, Sendit, a file sharing platform, Be Real, Dailymotion, and social network Viber, who have all reportedly made or committed to improvements around how they handle children's data. So Edwards says, as the usual ICO kind of language in these press releases goes, the message is simple. If social media and video sharing platforms want to continue operating and benefit from operating in the UK, they must comply with data protection law. That is simple enough, but balancing data protection and online safety obligations for children is far from straightforward. Together with guidance on the Online Safety Act we might be getting soon from the UK's media regulator, Ofcom, in fact I think we've recently got that, the ICO's investigations, they might help to explain how businesses should be getting this right, balancing people's privacy with their obligations to protect children, particularly by assessing users' ages. But it's no easy feat. Now, next up, the Court of Justice of the European Union has published a very important judgment about automated decision making and the right to meaningful information. So the background here is the data subject's called CK, and she applied for a mobile phone contract but was rejected based on an automated creditworthy assessment by the defendant, DNB. Now, CK requested information from DNB under Article 15(1)(h) of the GDPR, which entitles data subjects to meaningful information about the logic involved in decisions if they fall under Article 22 GDPR. So that, of course, includes credit checks. Now, the information D&B gave CK appeared to show her credit was perfectly good, so perhaps she should have got the contract. So when she pressed them further and regulators got involved, D&B ultimately refused to give any more detail, claiming that to do so would expose the company's trade secrets. And the case back and forth ended up at the CJEU, with the referring court asking for an interpretation of various issues around Article 15(1)(h) GDPR. Now, I have seriously simplified the questions here. They are very long. It's worth reading the judgment, but the CJEU, of course, is not well known for its brevity. So here are the core kind of issues. What is meaningful information about the logic involved? According to Article 15(1)(h) of the GDPR. The court sets out exactly what that should look like. It should explain the procedure and the principles actually used in the automated decision making about the data subject, such as profiling for creditworthiness. It must be provided in a concise, transparent and intelligible, easily accessible form, and it must enable the data subject to verify whether the automated decision is accurate and kind of see the link between the processing and the decision itself. And there was some debate about whether this should include actual bits of the algorithm or complicated mathematical formula underpinning it. No, that's not meaningful for the average data subject. So we don't need to provide actual maths. We just have to explain the decision in as simple terms as we can. Not an easy task, but that is what is required. Now, if the information can't be provided without infringing the rights of third parties, remember the GDPR says you should not denigrate other people's rights when responding to a subject access request. If that's the case, and the information wouldn't be meaningful otherwise, the controller should submit the information to a court or a data protection authority who will balance the competing interests at stake and decide what can be disclosed to the data subject. And the same goes if the information includes trade secrets. You have to give it to a court or a data protection authority and they'll make the decision for you. I think some companies will be quite hesitant to submit their trade secrets to some of the more data subject friendly DPAs, but there we go. This is what the court says they will have to do. Finally, national laws that exclude trade secrets by default from the right of access, as was the case here in Germany, are not compatible with the GDPR. It has to be a case-by-case thing, as always. So finally, in California, the Attorney General Rob Bonta has announced an investigative sweep concerning location data. So AG Bonta says that some advertising networks, mobile app operators and data brokers appear to be in violation of the California Consumer Privacy Act, the CCPA, due to how they share location information. And the enforcement sweep focuses on one of the CCPA's more complicated provisions. This is the right to limit the use and disclosure of sensitive personal information, which includes geolocation if accurate to within 1,750 feet. Now, if a consumer exercises their right to limit, as it's known, a business may only use the consumer's sensitive personal information for one of 8 purposes, and these are quite helpfully set out in the California Privacy Protection Agency's regulations, which were last updated last year, I believe. So to summarize, these are the 8 reasons that you can use someone's sensitive data, even if they ask you not to. By default, of course, you can, within reason, use it however you like. California is an opt-out state. It's not a consent-based regime, as we're seeing in other states with comprehensive privacy laws. So it's things like performing the goods and service that they've requested. So navigation apps, for example, need to use precise location data, so that's excluded from this right to limit. Gaming apps perhaps do not need to use location data. There might be some exceptions, Pokemon Go or whatever, but in general, this is core services you can use sensitive personal information for. A lot of these exceptions are not relevant to location data, but to sensitive personal information more broadly. One of them, for example, ensuring physical safety. You can share geolocation data with law enforcement in cases of suspected kidnapping. But none of these purposes include targeted advertising or selling data to data brokers, those kinds of commercial activities. So businesses must stop using precise location data for those purposes if requested. And you have to set up a means for consumers to make this request if you do sell or use sensitive personal information for non-exempted reasons. So that's all from me this week. Thank you so much for your time and attention. Thank you again to Privado AI